Well, hello everyone, or good afternoon, or good morning, frankly, depending on where you are. My name is Lior Samfiru, and let me start by welcoming you. Thank you for joining me on this session. Again, my name is Lior Samfiru. I'm an employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. We're the largest employee side law firm in Canada. And why are you here and why am I here? Well, I'm here live right now to answer your questions. I am here to talk to you about employment law, about workplace rights. I'm here to ensure that you know what you need to know if you're dealing with a workplace problem. Someone indicated that the audio is terrible. Dan, let me know if you think that's the case on your end as well. I'll try something here on my end. Okay. Let me know if this is better. But I'm here live today, and I'm here live to answer your questions. So if you're watching, listening, type your question. By asking the question, you'll get some legal information. You'll get answers. You'll know what you need to know about your workplace rights. So don't be bashful. Don't hesitate. If there's any issues that you want to know about, now's the time to ask those questions, okay? Anything. You lost your job. Maybe you're put on a leave. Maybe you have questions about vaccines. Can your employer mandate the vaccines? Maybe you're on a temporary layoff. Maybe you're being mistreated, harassed, or bullied in the workplace. Whatever the issue, whatever the problem, you have your keyboard, type in the question, I will answer it. That's the only reason I'm here for the next 30 minutes or so, is to answer your questions, to make sure that when you leave here and you shut off your computer, you know more than you did coming in. You know what to do. You know what your rights are, what your legal options are. That's the point. Now, before we get started, of course, let me give you some other contact information. If you want to connect with me and my team off social media, you want to have a private discussion or a private email exchange, not a problem. Here's what you do. You just go to employmentlawyer.ca. Again, employmentlawyer.ca. You see the address at the bottom of the screen. Phone numbers are there. Email addresses are there. Forms, if you want to fill out a form, it's all there. You can connect that way. So if you don't get your question answered or you're not sure how to ask the question, that doesn't mean you give up. That means you can still have a private discussion. Just go to employmentlawyer.ca. But for the rest of this session, I am live. Take advantage of the fact you have one of the top employment lawyers in the country here for the sole purpose of trying to answer your questions to help you. So I'm going to start answering questions right now. You have time, post yours too. Now, first question of the day on YouTube from L. Let's say you work for ABC company for 20 years. Then ABC move you to their sister company where there's no vaccine requirement. Are you still entitled to severance pay from ABC company? So ultimately, is if you lose your job, you're entitled to severance pay. Now, both in that scenario, both ABC and the sister company are on the hook, if you will, for severance. Okay, but as long as there's no government mandate, if we're talking about vaccines, if you lose your job in that scenario, yeah, you're going to be owed severance. But you get your job not if you're moved. Now, the only time ABC would have to pay you severance because they move you is if the job with the sister company is very different. Different hours, different pay, a demotion. But if they move you and you continue working doing essentially the same thing, then no problem. You can continue working, your seniority carries through. And if you lose your job, that's when you get severance. If there's another aspect to this, or if I didn't answer your question or misunderstood it, I'll just ask again. I'm here, happy to answer it. So the next question is from Pear or Pare. Sorry, I don't know. I mispronounced. I do apologize. I hate mispronouncing. Hopefully, I didn't. On YouTube, how is it possible for employers to mandate a vaccine with coercion tactics? Isn't this absolutely illegal? So what our courts have said actually is the government is, not the government. I'm sorry, that the employer is not mandating a vaccine. They're not saying you have to get a vaccine. They're simply saying to work here, you have to get a vaccine. So they're not coercing people to get a vaccine. They're simply saying if you don't get a vaccine, you won't work here. They have to pay severance. But keep in mind, an employer can always let you go. An employer can let you go because you chose to buy a blue car and they like people with red cars. That doesn't mean that's coercion. That means they have to pay you compensation if they let you go. Okay, so remember, the law is such that an employer can let you go pretty much for any reason as long as they pay you severance. So that when it comes to vaccines, think about it that way. Your employer is exercising its rights to let you go in a certain condition, but the fact that you've refused to get a vaccine doesn't deprive you of severance. You still are owed severance, okay? So that's how that pans out. So it's not accurate to talk about coercion, etc., and it's not necessarily illegal. It's a question of severance. Next question, I think it's a follow-up from L. How is severance pay calculated if you work in sales and are paid a small base salary plus commissions? Absolutely great question. So the way severance is calculated is we look at an average. So let's say on average a month you get a salary of $3,000 plus $5,000 commission on average. That's $8,000 a month. That $8,000 figure is what we would use to calculate your severance. If you're owed 5 months severance, it's going to be 5 times 8. So that's how it is. So it's not just base salary. We look at all components of your compensation: salary, bonus, benefits, commissions, stock options, car allowance, whatever it is, they all have to be included as part of your severance. When it comes to commissions, we look at an average. Depending on how long you've worked there, we either would do a 12-month average, a 3-year average, depending on how long you've worked there. Okay, hopefully that helps. That helped you understand. Lots of questions coming in. Again, to get information, to connect with me off social media, employmentlawyer.ca. Again, employmentlawyer.ca. Right now, we're answering more questions. From Grant, I was called into the office, and the same management and that same meeting let go immediately without cause. I was told I didn't need a second band rep. Well, they're allowed to do that, but it's a question of severance. So the real question is, Grant, not why they let you go, how they let you go, is what severance you're owed and what you've been offered. Now, assuming you're not part of a union, by the way, everything we talk about today only applies to non-union employees, only to non-union employees. So Grant, if you tell me about how long you've worked in your job and your age, I can tell you how much severance you're owed. But for Grant and for anyone else, if you want to find out right now how much severance you're owed, very easy to do. Grab your smartphone, your tablet, your laptop, whatever you want, and go to pocketemploymentlawyer.ca. You see at the bottom, pocketemploymentlawyer.ca. We have our severance calculator tool there. You can find out in seconds how much severance you're owed. Is it 6 months? Is it 24 months? Is it something else? Go to pocketemploymentlawyer.ca. Completely free, completely anonymous. Takes 5 seconds, and you can get your answers right there. So, Grant, you're owed severance. And chances are, whatever they've offered you, again, assuming you're not part of a union, is a lot less than what you're owed. If that's the case, you have to give me a call as soon as possible. Next question is from Mark. What are my options if I have been on a temporary layoff for a long time? I've been on an unpaid leave for 1.5 years and cannot continue like this. So your option is very simple. You can treat this, Mark, as a termination of your employment and require the company to pay you severance. Now, depending on how long you've worked there, that could be as much as 2 years' pay that they have to pay you. All right? So the options are you continue working and you sit at home and hope at some point you hear back from them. Option 1. Option 2, which I think makes sense if you've been off for that long, is to say enough is enough. I am choosing to treat this layoff as a termination. I am making that decision. And I'm now going to be owed severance. Mark, if that's what you want to do, you don't have to wait, not a day, not a week, nothing. You want to give us a call now, as soon as possible, so we can get this going and get you compensated quickly. Okay? So Mark, just go to employmentlawyer.ca. You see that on the screen below me, employmentlawyer.ca. Phone number is there, email address there, it's all there. So Mark, that's what you have to do. Next question is from Demonique on YouTube. Guys, ask your question as well. If your employer is raising the base pay for everyone in position in the company, can they leave behind employees based off of perceived performance issues and keep paying them less? Yes, they can. An employer is not legally required to provide a pay raise or to provide a pay raise for certain people. So they can choose. I'm not saying it's a good thing. I'm not saying it's good business, not at all. But from a legal standpoint, they can do that. They can say, we haven't been as happy with Joe's performance this year, so we're not going to give Joe a pay raise. We're going to maintain their salary. They can do that. Yes, they can. Obviously, ideally, they should have a good reason, but legally, as long as they don't reduce pay, they can do that. So Pear says that they're putting people on unpaid leave without severance. Absolutely, that's exactly what they're doing, but they're not allowed to. In other words, if you've been put on an unpaid leave, you can choose to get severance. You can choose to treat that as a termination. Okay, the law considers that to be a constructive dismissal. So it's not coercion, it's simply a constructive dismissal, which is a common thing in employment law. So if you've been put on an unpaid leave, you can choose to treat that as a termination and require them to pay severance. They may not want to, they may not think that they should, it doesn't matter. The law takes care of that. So if you're in that situation, let's talk, let's make sure you get your severance. Next question on Facebook from Leslie. I recently missed 5 days of work because of an assault at work, triggered my anxiety. When I reported the reason for missing work, my HR woman told me that I did not reveal the name of the person who assaulted me, that if I didn't, I would be disciplined by way of a written warning. I'm unwilling to give the name because that person is a supervisor and is vindictive. My question is, can the company actually reprimand me? So, first of all, that HR person should be fired, as far as I'm concerned, okay? You don't reprimand someone in that situation. It's ridiculous. But the reality is that reprimand from a legal standpoint doesn't mean anything. It doesn't impact anything. It's not something that the law intervenes. Now, if they suspended you without pay, if they let you go, that's very different. So there's not much you can do about a reprimand. The law can't make a company take that back, okay? But if at some point they try to use that against you, for example, say, well, now we're not going to give you a raise, or now we're not going to give you your vacation choice, something like that, then that may be considered a constructive dismissal. We should talk at that point. But the law can't actually physically stop your employer from giving you a reprimand, as silly and ridiculous, frankly, as that is, if the situation is as you've described. So hopefully that helps clarify. If it doesn't, let me know. Happy to do a follow-up with you, Leslie. You can always reach out to me, you, Leslie, and anyone else, through employmentlawyer.ca. Again, employmentlawyer.ca. All the contact information you'll ever need is there. You see it on the screen, employmentlawyer.ca. Okay. Pierre said it's not coercion. An employer can let you go for any reason. So I think we've covered that. Next question on YouTube from Lena. If the ROE will say fired for cause, but you said it can be changed to what? So it's a big change to a without cause termination. Oftentimes we use the code K for other, but that happens all the time. So if you are let go supposedly for cause because you didn't get the vaccine, that's not cause. It's not, unless there's a government mandate. If there's no government mandate that applies to you, it's not cause. Meaning, number one, you're owed severance, despite what your employer is saying. And number two, you should be getting, a revised record of employment that would allow you to apply for EI. But here's the thing. You will not be able to do this on your own. No chance. Okay, you will not be able to get severance. You will not be able to get a new record of employment. We would have to get involved. Okay, we'll have to invoke the legal process that's available to do that. So if you are in that situation, Lena, you have to give us a call, contact us, email, whatever you want. As you see on the screen right below me, employmentlawyer.ca is your starting point. All the contact information is right there. Okay, so hopefully that answers it. L on YouTube, can you get EI if you get sacked for not being vaccinated? So as I was telling Lena just now, yes, you can, but you will need a new record of employment, right? We will need to get involved to get you that record of employment. The record of employment that your employer is going to give you is very likely going to say something that would disqualify you from getting EI. That's why we have to get involved, because yes, you should absolutely be getting EI. Next question is from Grant on YouTube. I was under a 6-month contract, but they let me go 2 months before that 6 months. Can I get the 2 months pay from the contract that was left on it? Yes, absolutely. So the basic rule, the general rule is if you're on a fixed term contract, a contract for a specific period of time, and you're let go before the end of that contract, company has to pay you the balance. Have to pay the number of weeks or months or years that are remaining on that contract. So Grant, if there's 2 months remaining, they have to pay you. Now, the only time they may not have to is if the contract has what I call an early exit clause, where it specifically provides them with the opportunity to let you go before on some basis. Even if it has that, Grant, I still need to see it, because you may still be owed the balance of the contract, okay? So don't assume just because the contract says something that it's going to be effective. So I need to see that contract. But the general rule, absolutely, you have to get the balance of the contract if you are let go before the end of the term. Okay, hopefully that answers. Let's see. Okay, next question is from Karen on YouTube. Have any of the lawsuits for severance been successful due to mandates? I can tell you, yeah, we've already resolved cases, so absolutely, no question. Next question is from Lena. So Lena, we usually would call people back within 24 hours, okay? In really busy times, it could be 48, but that's how long it takes. Let's see. From Tony on Facebook. What if they put in code N for reason? Code N is leave of absence. So if you accept the leave of absence, if you continue staying on that leave of absence, then leave of absence is fine. You can apply for EI. If you choose to treat that leave of absence as a termination, because an employer doesn't have the right to put you on an unpaid leave of absence, then we would need to get you a new record of employment. But the other problem is with Code N is EI may ask your employer a follow-up and say, okay, why is he on the leave of absence? And if your employer says because he refuses to be vaccinated, EI may say, no, we're not going to pay. All right, so that's why we need to get you a proper record of employment saying termination without cause. But the only way, there's really only one way to get a new record of employment, and that is we would have to get involved. You will not be able to do that on your own, okay? Okay, so I think, Tony, I answered what happens. Again, if you don't agree to go on a leave of absence, you can choose to treat that as a termination. Again, as long as you're not part of a union and as long as there's no government mandate that applies to you. Okay, next question is from Sharon. I'm currently on paid leave as per HR direction, as I'm unable to do the weekly testing. I'm waiting to hear from them about whether they are firing me. Am I entitled to severance 30-year bank employee? Well, yes. Now, especially if there's a medical reasons, but even without that, you may well be entitled to severance in that situation. So if they let you go, now keep in mind, when it comes to severance, we can't deal with it preemptively. We can only deal with it once your employer does something. If they let you go, if they suspend you, if they put you on a leave, that's when we can get severance. So yes, you would be entitled to severance here. I will say this to make your situation even stronger. If there's a medical reason why you can't get your weekly testing for whatever reason, and you can get a doctor's note, get that doctor's note. That makes the situation that much better for you. In your case, that much stronger. Always ideal. I know sometimes it's not possible. If it is possible, that's what you want to do. Next question from Per. As I understand it, under common law, if I don't have a contract with the government or employer to get vaccinated, how can they enforce placing employees on unpaid leave? As I said, they can't, right? An unpaid leave is a termination in the eyes of the law. So I've said that several times. If you're put on an unpaid leave, no, an employer does not have a right to do that, again, unless there's a government mandate. And in which case, if you are put on a leave, you can choose to treat that as a termination of your employment. So you can't, and I want to make it something clear. If your employer does something they're not supposed to do, like put you on an unpaid leave, you cannot physically stop them. There is no legal mechanism available to physically stop your employer from doing something. No. All that means is that there's legal consequences if they do that. They're going to have to pay compensation if they do that. So that's how the law operates. So people, especially when it comes to vaccines, say, well, it's illegal, so how can they do that? Well, no, they can do it. There's no way to stop them, okay? But compensation is going to have to be paid. So don't think in terms of legal or illegal. Think in terms of, are you owed compensation, okay? And that's where we get involved. All right, next question is from Belinda. How can I deal with my employer trying to force me into retirement? I've worked there for 22 years and I'm not ready to retire. It's very simple. You simply say very clearly and even send an email, I'm not retiring. If and when I change my mind, I will let you know. That's it. They cannot make you retire. They cannot force you to retire. They cannot make you quit. None of that. But you do that. And by the way, if you say that and say that in writing, and you can show that they're still putting pressure on you, that itself could be a human rights violation. If your employer is saying, come on, you're getting up there in age, you should really retire. If you can show that that's what's happening, that's illegal. Even that pressure itself could be a human rights violation. But how do you deal with it? You make it very clear. I am not retiring. Full stop, period. Done. And there's nothing they can do about that. You can work there for till 65, 75, 85, whatever you choose. There's nothing they can do about that. We don't have mandatory retirement in Canada. So because of that, you do what you need to do. Next question from Sarah. I chose to accept testing as I found out I had to move. If my employer at some point decides that all employees must be vaccinated with no testing available any longer, would I still qualify for severance? I'm not a federal or unionized employee. The answer is absolutely yes. If your employer says you have to be vaccinated, if you choose ultimately not to, and if because of that you are let go or suspended, absolutely you're going to be owed severance. I think you did the right thing by agreeing to testing. If they allow that, that's great, and you continue working, no problem. But if that policy changes at some point, unless, of course, in the meantime, there's a government mandate that comes into play that applies to you. But if there isn't, it doesn't sound like right now there is, you will absolutely be owed severance, no question. And if that happens, as soon as that happens, you contact us. And take a pause here for a second before I continue questions to reach out to me, to reach out to my team. For those just joining us, very easy, employmentlawyer.ca. Again, those joining us, my name is Lior Samfiru. I'm the employment lawyer, filing partner at Samfiru Tumarkin LLP. I'm answering questions now, but I'm only doing that for the next 7-8 minutes or so. After that, not going anywhere. Still available to answer questions, still available to help you, still available to help you get your severance. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. Phone numbers are there, email addresses are there. Everything you need is right there so we can connect. But right now, still here, you still have time. Ask your question, I will answer it. Next question from Karen. While on the leave of absence and applying to job ads that don't stipulate vaccine mandates, they call for an interview request. At the end of the interview they call for an interview and request at the end of the interview that you have to be fully vaccinated. Is that legal? Well, I say that arguably it's not, but there's not going to be much that you can do about it. You have to accept that right now, if you're not vaccinated, it's going to be very difficult to find another job. You're not going to be able to do much about it. You're not going to be able to legally force someone to hire you. But if you've been put on a leave of absence, Karen, you can treat that as a termination and get severance. Again, as long as you're not part of a union. So in the meantime, you can get some compensation and you can get EI. So that gives you some more time to find a job. And if it gives you more time, hopefully by the time the money runs out, maybe things are better. We'll see with the pandemic, and maybe there's no need for mandatory vaccinations. So the question is not so much, is this legal? Arguably, it's not much you can do about it. The key then is to get severance from the employer that puts you on a leave. To do that, you reach out to us and we'll help. Next question from Sharon on Facebook. If you get involved in a no severance situation, do you only charge your fee after you are successful in getting compensation or before, even if not successful? The vast majority of our cases, Sharon, probably 80+%, are on the basis that we only charge if we're successful. Only if, and we take the risk and we don't charge anything in advance. And if we're not successful for whatever reason, the person doesn't pay anything at all. We take that risk 100%. We can't offer that in every case, but we offer that in almost every case, over 80-85% of them. So that's our general rule. So that's why you don't have to worry about that risk. If you are in that situation, you lost your job, you don't have severance, you've been put on leave, let's talk and let's see how we can help you. Next question comes to us on YouTube from Lena. Were your cases they will resolve by court or just your involvement without court? Do we sue employer if they fire because not being vaccinated, or just talk to them? So in some cases we have to take legal action, in some cases we don't. But here's the thing, 99% of all employment cases resolve without having to go to court. Court is a dirty word. You don't want to go to court. It takes long time. It's not a fun process. No one wakes up in the morning and says, gosh, I can't wait to go to court. It's going to be such a good day. Never happened. No one ever said that. That's why matters resolve. They settle on good terms, often very, very quickly. Okay? So there have not been any court decisions dealing with this, but they don't need to be. And frankly, there may never be any court decisions. They may never be. They may or may not. And my goal is not to go to court if I don't have to. I will go to court if there's no other way. But if I go to court, that means something I did didn't work. All my strategies failed. So for me, going to court means I failed. It means I didn't do my job the way I wanted to do it. So that's why we resolve cases. Okay. Next question from Dan on YouTube. Are federally regulated industries mandated the same way that federal employees are mandated? Or do those industries have a choice? So the federal government has announced that in the new year, they're going to mandate all federally regulated employees to be vaccinated. Number one, that hasn't happened yet. Number two, even if they mandate, we don't know what the exceptions are going to be, and we don't know what the timeline is going to be on that. They've announced that it's going to happen. It may or it may not. So that's all we know. Now, keep in mind, not everyone that is a federal employee that works for the government is mandated. Only certain core departments are mandated. So there's many people that work for the government that have no mandate that applies to them. Okay, so let's be very clear that it's not every employee that works for the federal government is mandated. Not at all. Most, in fact, are not. Okay. So next question on YouTube from Mile Nap Pellegrini. Sorry. Can an employer change your pension contribution plan after 15 years that you've contributed? No, that may be a constructive dismissal. So you may have to choose to treat that as a termination and leave with severance. So again, you can't physically stop them. But before you make any move, we have to assess what the change is, how it's going to impact you financially. We would have to talk about that. Okay, so you have to contact us. So Sharon asks, if the government mandates the vaccine, are you then not entitled to severance? So yes, you're not entitled. And the reason for that is this. If your employer doesn't have a choice but to have people vaccinated, because the government says you must have your employees vaccinated or we're going to fine you or we're going to shut you down, then the employer has no choice. So it's not the employer's decision. And if it's not the employer's decision, if you refuse to be vaccinated, no severance is paid. On the other hand, if the company's making the decision, government is not saying we have to, but we've decided that we're going to let people go if they don't get the vaccine. At that point, they have to pay severance. So yes, if the government mandates a particular employer or a particular industry to have all its employees vaccinated, if you're one of those employees and you don't get vaccinated, you're not going to be owed severance. Okay. From Robin, the government has signaled they will be mandating the rest of federally regulated workplaces in 2022. That's true. If we are terminated before the end of this year, is there any case for them to terminate without severance at this point? No. If they terminate before the new laws and new rules come into effect, your employer would have to pay your severance. Absolutely. Even if you've just been suspended. Okay, last question. From Joker 32411. Employer wants me to complete vaccine attestation question. Says there will be disciplinary action if not disclosed. Disclose it. Okay. If you disclose and they let you go, suspend you, that's the best way to fight it. An employer should know if you've been vaccinated or not. There's safety reasons so they can take certain measures. That doesn't mean that they can legally let you go without severance if you're not vaccinated. But my advice, complete the attestation form, okay? Could you get severance if you don't complete it and are let go? Yeah, probably, but it actually makes it more difficult, okay? So that's how I look at it. All right, guys, our time today is up. So I'm gonna end this here, but I know there's more questions. That's fine. I'm not going anywhere. I have a whole team, 40 lawyers across Canada, ready to help. We've been helping hundreds, if not thousands of people with these issues over the past few months. Contact me if you want. Employmentlawyer.ca. Again, employmentlawyer.ca. And remember, of course, to calculate and find out how much severance you're owed at pocketemploymentlawyer.ca. We have our severance calculator feature there. My name is Lior Samfiru. I'm the employment lawyer with Samfiru Tumarkin LLP. I'll be back, but don't wait until that happens. Let's continue that discussion now. Employmentlawyer.ca. Thank you, everyone, for joining. I hope you have a good rest of the week.